Hello, welcome back to Legal Brain. Today I'll be discussing about yet another important topic, and that is privity of consideration and its exceptions. So, when it comes to the concept of consideration, we all know that consideration is an essential element, or it is also known as the lifeblood of a contract. And the definition for consideration is given under Section 2, Subclause D of Indian Contract Act 1872. And we know it is an essential element when it comes to a contract. It's a valid essential. Now, I will be discussing about what do you mean by privity of consideration. So you can look into the screen and try to understand what do you mean by privity of consideration. The concept of privity of consideration arises from the concept that who should give or who should provide the consideration when it comes to a contract. In simple words, when the contract is between the promiser and the promisee, the promisee is supposed to furnish the consideration to the promiser. And there is a difference in law in England, in English law and in Indian law. In England, it says that the consideration must always move from the promisee and not any other party. That means a third party or a stranger to the contract or a person who is not a party into the contract should not provide the consideration, and that is not valid in the eyes of English law, which says that if it is furnished by any other person other than the promisee, then the promisee becomes a stranger to the consideration and therefore cannot enforce the promise. So, which mandatorily says that the consideration should always move from the promisee when it comes to English law. And there is a difference when it comes to Indian law. And in Indian law, it says that the consideration can be moved from a third party or a stranger to the contract. So before that, one more line is that the promisee seeking to enforce an agreement must show that he himself furnished the consideration for the promise given by the other party, which says that always it is the duty of the promisee to furnish the consideration and show that he is the person who have paid the consideration or made the consideration. And this particular concept or the principle is known as doctrine of privity of consideration. And now I'm going to discuss about the concept in India. In India, as I've already mentioned, doctrine of privity of consideration is not applicable in India, which means that any party, any third party, or a stranger to the contract can actually give the consideration to the promisor. For example, there are two parties, A and B, and they made a contract, and now B has to furnish consideration to A. According to English law, only B, the promisee, is supposed to give the consideration to the promisor A. But in Indian law, it is different, and it says that any other party, for example, C, who is a stranger to the contract, which means he is not a party to the contract, still he is legally eligible to pay the consideration to the promiser, and that is not a problem in India. And there is a supporting case law, that is Nihal Singh versus State of Punjab 2013 case, and this is a Supreme Court decision, and Supreme Court held that consideration for a contract need not always necessarily flow from the parties to the contract. That means a third party or a stranger to the contract can actually give the consideration. So this was a positive judgment given by Supreme Court of India when it comes to consideration and doctrine of privity of consideration. And next, I would like to discuss about nudum pactum, and the meaning is an agreement without consideration is void. We have already learned that in valid essential, consideration is an essential element, and there should be consideration in a contract. And here it says that if there is any agreement or an agreement without consideration, what will be the effect of that particular agreement or the contract? And it says that if at all the agreement without consideration is there, then it is void in nature, and that is not valid in the eyes of law, and which will be an void agreement. And there is a very important legal maxim, and that is ex nudo pacto non oritur actio, which is a legal maxim. And the meaning of this particular legal maxim is that no action arises from a nude agreement. So, nude agreement or bare agreement, the meaning is an agreement without consideration. So, an agreement without consideration can be known as nude agreement, bare agreement, and this is called nudum pactum. That means an agreement without consideration is always void in nature. And look into the screen and try to understand. It says that no action arises from an agreement without a consideration, which says that consideration is essential and it should be there in a contract. The second point says that an agreement without consideration is known as nudum pactum, and which is always void in nature and which is unenforceable. The next point says that there are certain exceptions to this particular general rule, which means there can be agreements or there can be contracts without consideration and which will be valid under certain exceptions. And there are mainly 3 exceptions, and I'll be discussing about the exceptions to this specific rule. And the exception, the first one is that love and affection, and which says that, for example, a written or a registered agreement based on natural love and affection has been made between 2 parties or close relatives, then which will be enforceable even though there is no consideration. For example, look into the screen. One person, F, for natural love and affection, promises to give his son rupees 1,000. Okay, so it's like a father promised son to give a pocket money of 1,000 rupees because of love and affection, and they entered into a contract and he actually write down and registered that. So now F puts his promise into writing and registered it. And what will be the effect of that? This is a valid contract, even though there is no consideration from the part of the son for his father. So this is a clear example which says that if you have made or if you have entered into a contract or an agreement because of love and affection, and there is no consideration from the promisee to the promiser, then it is not at all a problem. This is an exception to the general rule and which will be a valid contract and which will not be void in nature. The second point is that compensation for voluntary services, which means that, for example, you have done a past voluntary services, voluntary, which means you yourself have done a particular act, and that is a service, let it be like that. Suppose you have done an voluntary service in past, and now which can be treated into the present situation. And it says that a promise to pay for a past voluntary service is binding even though there is no consideration from the promisee to the promiser. Example, A finds B's lost purse. One lost purse was there, and A actually found out the particular purse and gave it back to him. In this situation, B promises to give like a reward of 50 rupees. Here, it should be treated as a contract and which is valid in nature, even though there is no consideration, because which is falling under the exception past voluntary services, like compensation for past voluntary services. The next exception is that promise to pay a time-barred debt. And the meaning is that, for example, a promise by a debtor to pay a time-barred debt is enforceable. For example, one particular person is supposed to pay, the debtor is supposed to pay a certain amount to the creditor, the person from whom he has taken the money, and now the time period is over, he should give back the money, but he haven't given the money. If this is a situation, and this particular person is giving a promise that the promise should be in writing and should be signed by the debtor or his agent, like to whomever he is authorized to do so, then this particular promise may be like to pay the full of the amount, the whole amount, or any part of it, which is valid in the eyes of law, even though which is actually barred debt. For example, like there is Limitation Act and which is not falling under the specific time limit, even though the debtor is making an agreement with the creditor regarding the payment of money, regarding the payment of time-barred debt, which is treated as a valid agreement and not a void agreement, and which is an exception to the general rule. Look into the slide, you can understand like D owes C rupees 1,000, but the debt is barred by the Limitation Act. Limitation Act specifies a time limit to file a case or to make the payment, and he signs a written agreement to pay rupees to C rupees 500 on account of the debt. And this is the contract, which says that all the time bar debt can be treated, the promise to pay time bar debt can be treated as a valid agreement if it is made like write it down and which has been signed. And also, I've already mentioned like section 185, which says that no consideration is necessary to create an agency when it comes to agency, like between the agent and his principal. No consideration is necessary. And also, explanation 1 to section 25 of Indian Contract Act says that no consideration, no contract does not apply to gifts. So, gift is also an exception. So, these are the exceptions when it comes to privity of consideration. And also in India, we do have a settled rule regarding charitable subscriptions and charitable subscriptions, which means donations given for, like a trust or something like that. And this particular rule says that in India, if the law of charitable subscription has been settled down and it says that if one particular person have given a promise regarding like he will pay certain amount of donation to the other party, and if I've given a promise, then it become enforceable as soon as any definite steps has been taken by the particular person in furtherance of the particular thing. Like, I have promised that I'll give a certain donation to you on this particular date. I have promised it, and now I'm changing my mind and I'm not ready or willing to give the particular amount, which is actually enforceable. You can file a complaint against me. You can initiate a suit against me to get the particular donation from me if you have taken a further positive steps regarding that. There are mainly 2 points. The first one is that the promise should have taken, the promise should have taken certain positive steps in furtherance to the object of the promise subscription. The second point is that the promises should have taken some positive steps on the faith of the promise subscription. And there is a landmark case law, Naya Service Society versus Kunju Krishna Pillai. And in this case, it says that the defendant, Kunju Krishna Pillai, has agreed to this particular Naya Service Society that he will pay an amount of 10,000 rupees for starting a college, for setting up of college. And this particular Naya Service Society has started the construction of the college, and which is treated as a positive step or a positive initiative. So they have taken a positive initiative, and the defendant didn't pay any particular amount. So since they have started a positive initiative step, they could actually file a suit against the defendant and get back the money. And court in this case held that if the plaintiff have taken a positive steps with regards to the concept of like in belief or in faith regarding the object, or regarding in faith of the promise subscription, the defendant has to give the compensation. So these are the general topics which is falling under doctrine of privity of consideration. So I have explained what you mean by doctrine of privity of consideration, and I have also explained the exceptions to the general rule, exceptions 1 of section 25 and so on. And I have also mentioned certain important case laws and the concept of charitable subscription. I hope it's it's clear for you. If you do have any doubts, do comment below. And thank you for listening to the class. Thank you.